Good day, everyone, and welcome to Persons and Family Relations. Yesterday, we discussed Articles 14 to 40 of the Family Code, and today we will start discussing Articles 41 to 44 of the Family Code. This is the so called bigamous marriages. Okay, so let's now start by reading Articles 41 to 44. I'll start with Article 41. Article 41 provides that a marriage contracted by any person during the subsistence of a previous marriage shall be null and void unless before the celebration of the subsequent marriage the prior spouse had been absent for 4 consecutive years and the spouse present had a well-founded belief that the absent spouse was already dead. In case of disappearance where there is danger of death under the circumstances set forth in the provisions of Article 391 of the Civil Code, an absence of only 2 years shall be sufficient. For the purpose of contracting the subsequent marriage under the preceding paragraph, the spouse present must institute a summary proceeding as provided in this code for the declaration of presumptive death of the absentee without prejudice to the effect of reappearance of the absent spouse. Article 42. The subsequent marriage referred to in the preceding article shall be automatically terminated by the recording of the affidavit of reappearance of the absent spouse unless there is a judgment annulling the previous marriage or declaring it void ab initio. A sworn statement of the fact and circumstances of reappearance shall be recorded in the civil registry of the residence of the parties to the subsequent marriage at the instance of any interested person, with due notice to the spouses of the subsequent marriage and without prejudice to the fact of reappearance being judicially determined in case such fact is disputed. Article 43, the termination of the subsequent marriage referred to in the preceding article shall produce the following effects. First, the children of the subsequent marriage conceived prior to its termination shall be considered legitimate, and their custody and support in case of dispute shall be decided by the court in a proper proceeding. Number 2, the absolute community of property or the conjugal partnership, as the case may be, shall be dissolved and liquidated. But if either spouse contracted said marriage in bad faith, his or her share of the net profits of the community property or conjugal partnership property shall be forfeited in favor of the common children, or if there are none, the children of the guilty spouse by a previous marriage, or in default of children, the innocent spouse. Number 3, donations by reason of marriage shall remain valid except that if the donee contracted the marriage in bad faith, such donations made to said donee are revoked by operation of law. Number 4, the innocent spouse may revoke the designation of other spouse who acted in bad faith as a beneficiary in any insurance policy, even if such designation be stipulated as irrevocable. And number 5, the spouse who contracted the subsequent marriage in bad faith shall be disqualified to inherit from the innocent spouse by testate and intestate succession. Article 44 provides that if both spouses of the subsequent marriage acted in bad faith, said marriage shall be void ab initio, and all donations by reason of marriage and testamentary dispositions made by one in favor of the other are revoked by operation of law. Now, let us discuss these articles, no, pertaining to a marriage wherein the law would consider it as bigamous. Question, what is a bigamous marriage? When we talk about bigamous marriage, this is one contracted by any person during the subsistence of a prior or a previous marriage. Okay? Now, X contracted a bigamous marriage. What is the status of that marriage? Of course, before you answer that, you have to know the surrounding circumstance of that particular question. You wouldn't know the answer yet, if it is void, if it is valid, or terminable. A subsequent bigamous marriage may actually be a void marriage, a terminable marriage, or it can be terminable with penalty or valid under quotation. Question: when will it be void? This is provided for under Article 41 and 44. In Article 41, there are actually two types of void marriages. First is when there is no harboring a belief that the other spouse is dead, which is automatically void. You enter into a contract of marriage despite the fact that there is a subsisting prior marriage, and you do not harbor any belief that your spouse to that previous marriage is already dead. But nonetheless, you enter into a subsequent marriage. Naturally, your subsequent marriage is automatically considered void. Now, the second type is a subsequent marriage that is done under the belief that the absent spouse is already dead. When the present spouse harbors the belief that the other spouse is already dead, that's the time when the marriage is either void, terminable, terminable with penalty, or valid under quotation. Now, you may ask, how do we determine, attorney, the status? Again, you consider the character of faith. Okay? The character of faith of the parties. If both of the parties are in bad faith, automatic yan, void ang marriage. If only one of the parties to the subsequent marriage is in bad faith, the status is terminated with penalty. If both of them are in good faith, it can be terminated. But if there is no action to be made, or if there is no action made by the prior spouse, that particular marriage remains valid. In Article 41, guys, when the present spouse harbors the belief that the other spouse is dead and gusto niya na magpakasal kasi miss na niya na may asawa, in order for that subsequent marriage not to be considered as void, the following requisites must be present. First, the prior spouse had been absent for at least 4 years under normal circumstance. 2 years lang kung may danger of death, okay? Second, the spouse present has a well-founded belief that the absent spouse is already dead. Question: when is there a well-founded belief, or when is well-founded belief manifested? There are 2 requisites. 1, the disappearance of the absent spouse must be such a manner that death is likely to occur. Dili bastang nawala lang. Kailangan nawala and then pwede na mamamatay. Example, the other spouse went to England for 7 years. It doesn't mean that that spouse already died, because England is a relatively peaceful country. Except when that spouse of yours went to Iraq, or maybe when he went to Iraq or somewhere else na siya'y sakit. Diba? These instances would manifest that the disappearance of the absent spouse would be in such a manner that death is likely to occur. The second requirement is that the present spouse must conduct a diligent search. You may ask, when is search diligent? Kailan mo masasabi na yung pagsisearch mo talagang diligent? And why does the law would really require that there be a search? 'Di ba, if yung aso nga natin pag nawala, para tayong mababaliw pag nawala, 'di ba? And if it's your wife or your husband that is lost, ibang klase yung pagkakabaliw natin if they are lost, 'di ba? Because we have the right to consortium. So in order for it to be considered as a diligent search, you must really go out of your way to look for the absent spouse. Hindi pwede na tatanong ka lang dyan sa mother-in-law mo na, oh, nasan ba yung asawa ko? Eh, wala dito eh. Eh, okay na yun. No, not necessarily. Or you would go to the embassy. You would write the embassy, and if there's no response, you would say, wala na talaga yung asawa ko. There has to be a couple of searches na kailangan mong gawin, di ba? Pupunta ka sa radyo, sa television, sa internet. You will ask the authorities for help and all that. Kasi the Supreme Court is very strict on this one. And if these requirements are complied with, the present spouse will be considered in good faith. Diba? And if both spouses are in good faith, the marriage will be terminable. Bakit terminable? Why terminable? It only means na automatically terminated ang subsequent marriage nila by the recording of the certificate of reappearance. Nung unang panahon before the advent of the family code, yung civil code pa, voidable ito. But now, the family code would consider it as terminable. Meaning, valid lang siya. Valid pa rin siya as long as there is no recording of the certificate of reappearance. Now, what happens if the absent spouse is alive but did not file an affidavit of reappearance? What would be the effect? Yung subsequent marriage, as I've mentioned earlier, will be valid. However, may mga arguments yung mga authors ng books na for purposes of succession, the two spouses are basically the heirs of the present spouse. But of course, with respect to personal rights, yung subsequent husband ang may right. When you say personal rights, like the right to live with the wife or the present spouse, the right to make love with the present spouse, those are personal rights that the subsequent spouse can only exercise. Now, I repeat, under Article 41, in order for that subsequent marriage not to be considered as void, you have to satisfy the following requisites. Yung una, the prior spouse had been absent for at least 4 years or 2 years, as the case may be. Yung pangalawa, the spouse present has a well-founded belief that the present spouse is already dead. And the third one is that the spouse present institutes a summary proceedings for the declaration of the presumptive death of the absentee. That's provided for in Article 41 of the Family Code. And the fourth one is that the petition must state that the reason why the petition is filed is for purposes of remarriage. The Supreme Court would really require us to specify kung ano bang reason, bakit ba pinadideclare mo ang iyong asawa na absent na or presumptively dead. So you have to specify there in the reason, and that the reason is for purposes of remarriage. Alright, I repeat, under Articles 41 to 44, sabi niya, if both of the spouses to the subsequent marriage are in bad faith, automatic void yung subsequent marriage na yan. If only one is in bad faith, this is terminated with penalty. If both are in good faith, this is terminated. And if there's no action made by the prior spouse or the absent spouse, the marriage remains valid. Alright, so let's now proceed to Article 45. Article 45, ladies and gentlemen, gives us the grounds for the annulment of a marriage. Okay? They must exist at the time of the celebration of the marriage. And when we talk about a voidable marriage, this is considered valid unless it is annulled. Okay? So before the annulment, the voidable marriage must be regarded as valid. So ano-ano yung mga grounds for annulment of marriage? Under Article 45, it provides that the marriage may be annulled for any of the following causes existing at the time of the marriage. First, that the party in whose behalf it is sought to have the marriage annulled was 18 years of age or over but below 21, and the marriage was solemnized without the consent of the parents, guardian, or person having substitute parental authority over the party in that order, unless after attaining the age of 21, such party freely cohabited with the other and both lived together as husband and wife. Pangalawa, that either party was of unsound mind unless such party, after coming to reason, freely cohabited with the other as husband and wife. Number three, that the consent of either was obtained by fraud unless such party afterwards, with full knowledge of the facts constituting the fraud, freely cohabited with the other as husband and wife. Number four, that the consent of either party was obtained by force, intimidation, or undue influence, unless the same having disappeared or ceased, such party thereafter freely cohabited with the other as husband and wife. Number five, that either party was physically incapable of consummating the marriage with the other and such incapacity continues and appears to be incurable. Or number six, that either party was afflicted with a sexually transmissible disease found to be serious and appears to be incurable. So let's go now to number one. This is very easy. Ang requirement is kailangan may parental consent if you are between 18 to 21, absent which yung marriage mo becomes voidable. Except when you become 21 and you freely cohabit with the other and live together as husband and wife, cured na yung defect. Alright? Number two is if you are of unsound mind. Unless, of course, when you already come into reason and then you still freely cohabit with the other and you live together as husband and wife, yan, cured na rin yung defect. Number three would talk about the consent of the either party being obtained by fraud. So, ano-ano yung mga kino-consider na fraud under Article 46? Let's go to Article 46. Article 46 would provide that any of the following circumstances shall constitute fraud referred to in number 3 of Article 45. Una dyan, non-disclosure of a previous conviction by final judgment of the other party of a crime involving moral turpitude. Kailangan dinidisclose nyo if you have been convicted. Okay? If you do not disclose it, it becomes a ground for annulment of marriage under Article 45. Pangalawa, yung concealment by the wife of the fact that at the time of the marriage, she was pregnant by a man other than her husband. Ito yung nabuntis ka ng iba. But if it is your husband who got you impregnated, hindi yun covered under this particular provision. This reminded me of the case of Bukat versus Bukat and Aquino versus Aquino. The Supreme Court said, if 6 months or more na, halata na nga buntis yung babae, and if pinakasalan mo pa rin despite that condition, wala yung concealment. Okay? But if below 6 months pa yung pregnancy, baka plump lang talaga yung babae. So, this is what happened in Bukat versus Bukat. This case was actually decided in 1941, April 25, 1941. It was established before the trial court that the plaintiff actually met the defendant sometime in March 1938. And after several interviews, both were committed on September 19 of that year. On November 26 of the same year, the plaintiff married the defendant in a Catholic cathedral in Baguio. Okay? So, they committed on September 19. They got married in November 29. They met in March, okay, of that year, 1938. They then cohabited for about 89 days. And then the defendant in this case gave birth to a child of 9 months on February 23, 1939. So just do the math, okay? Following this event, si plaintiff and defendant separated. On March 20, 1939, the plaintiff filed an action for annulment of marriage before the RTC of Baguio City. The plaintiff claimed that he consented to the marriage because the defendant assured him that she was a virgin. So, the trial court dismissed the complaint. So, ni-appeal itong si plaintiff in this case. So the issue that was raised in the Supreme Court in this one is, should the annulment of the plaintiff's marriage be granted on the ground that the defendant concealed her pregnancy before the marriage. The Supreme Court said no. Clear and authentic proof is needed in order to nullify a marriage, a sacred institution in which the state is interested and where society rests. In this case, the court did not find any proof that there was concealment of pregnancy constituting fraud as a ground of annulment. It was unlikely that the plaintiff, a first year law student, did not suspect anything about the defendant's condition, considering that she was in an advanced stage of pregnancy and highly developed physical manifestation, such as enlarged stomach, when they got married. You have to be aware, according to the Supreme Court, as a law student, you have to be aware of the mundane things in the world because lawyers deal with everyday events. As she gave birth less than 3 months after they got married, she must have looked very pregnant even before they were married. Thus, in this case, consent was freely given. So, hindi na annul yung marriage ni Bukat against the wife Bukat. Alright? So, another circumstance that would constitute a fraud under Article 46 is the concealment of sexually transmissible disease, regardless of its nature, and it should be existing at the time of the marriage. Alright? Also, concealment of drug addiction, habitual alcoholism, homosexuality, or lesbianism existing at the time of the marriage. Basically, dito, non-disclosure and concealment ang pinaka-factor. And remember that no other misrepresentation or deceit as to the character, the health, the rank, fortune, or chastity shall constitute such fraud as will give grounds for action for the annulment of marriage. Okay? Now let's go back to paragraph 4 of Article 45. Sabi ng paragraph 4 that the consent of either party was obtained by force. Physical force, okay? Intimidation. Intimidation, example, nakabuntis ka and hindi mo pinakasalan. Tapos, tinakot ka na pag hindi mo siya pinakasalan, hindi ka makakapag-take ng bar. So, pinakasalan mo because of this fear and then you took the bar. Unfortunately, you didn't make it. Hindi ka nakapasa sa bar. Now, afterwards, can you file for an annulment of marriage on the ground that you were only intimidated when you entered into a contract of marriage dyan sa babae na nabuntis mo? The answer is no, because this kind of threat is enforced against one's claim through a competent authority. Diba? This is a valid and legal claim, and this will not be considered as intimidation contemplated in Article 45, Paragraph 4. And then undue influence, mas mataas yung rank sa iyo nung pinakasalan mo. Let's say employee-employee relationship, student-professor relationship. Okay? Unless having disappeared or ceased, such party thereafter freely cohabited with the other as husband and wife. Ito yung sinasabi natin earlier na if there's a cohabitation after nag-cease or after nag-disappear, yung ground for the annulment, talagang makukure yung defect in this instance. Paragraph 5, that either party was physically incapable of consummating the marriage with the other and such incapacity continues and appears to be incurable. No cohabitation will cure this defect because this should be permanent in nature. And when we talk about impotency, this must be the kind of impotency that is permanent. Kaya walang cohabitation, okay? Number 6 is that either party was afflicted with a sexually transmissible disease found to be serious and appears to be incurable. Katulad noong previous paragraph, there's no cohabitation because the presumption is this kind of defect is permanent in nature. Article 47. Article 47 provides or enumerates for the persons who may sue for annulment of the marriage and the respective prescriptive periods. Starting off with paragraph 1, the action for annulment of marriage must be filed by the following persons and within the periods indicated herein. For causes mentioned in number 1 of Article 45 by the party whose parent or guardian did not give his or her consent within 5 years after attaining the age of 21, or by the parent or guardian or person having legal charge of the minor at any time before such party reached the age of 21. Number 2, for causes mentioned in paragraph number 2 of Article 20 or 45 by the same spouse who had no knowledge of the other's insanity, by any relative, guardian, or person having legal charge of the insane at any time before the death of either party, or by the insane spouse during a lucid interval or after regaining sanity. For causes mentioned in number 3 of Article 45 by the injured party within 5 years after discovery of fraud. For causes mentioned in number 4 by injured party within 5 years from the time the force, intimidation, or undue influence disappeared or ceased, and for causes mentioned in numbers 5 and 6 by the injured party within 5 years after the marriage. Article 48. In all cases of annulment or declaration of absolute nullity of marriage, the court shall order the prosecuting attorney or fiscal assigned to it to appear on behalf of the state to take steps to prevent collusion between the parties and to take care that evidence is not fabricated or suppressed. In the cases referred to in the preceding paragraph, no judgment shall be based upon the stipulation of facts or confession of judgment. In this article, ang sinasabi lang naman nito is the prosecutor's role with respect to cases of annulment or absolute nullity of marriages. The role of the fiscal is to really ensure that they take steps to prevent collusion. Dapat hindi kukulud yung mga parties in this case. Sa Bisaya pa, wala nagsabot. Okay? And the fiscal has to take care that the evidence is not fabricated or suppressed. If ever madiscover ni fiscal na there was collusion or there was fabrication or suppression of evidence in this case, the case for the annulment or declaration of nullity of marriage may be dismissed. Okay? Article 49. Article 49 provides that during the pendency of the action and in the absence of adequate provision in a written agreement between the spouses, the court shall provide for the support of the spouses in the custody and support of their common children. The court shall give permanent consideration to the moral and material welfare of the said children and their choice of the parent with whom they wish to remain as provided for in Title 9. It shall also provide for appropriate visitation rights of the parent. Article 50. The effects provided for in paragraphs 2, 3, 4, and 5 of Article 43 and in Article 44 shall also apply in proper cases to marriages which are declared void ab initio or annulled by final judgment under Articles 40 and 45. The final judgment in such cases shall provide for the liquidation, partition, and distribution of the parties of the spouses, the custody and support of the common children, and the delivery of their presumptive legitimes unless such matters had been adjudicated in previous judicial proceedings. All creditors of the spouses as well as the absolute community or the conjugal partnership shall be notified of the proceedings for liquidation. In the partition, the conjugal dwelling in the lot in which it is situated shall be adjudicated in accordance with the provisions of Articles 102 and 129. Article 51. In said partition, the value of the presumptive legitims of all common children computed as of the date of the final judgment of the trial court shall be delivered in cash, property, or sound securities unless the parties by mutual agreement judicially approved had already provided for such matters. The children or their guardian or the trustee of their property may ask for the enforcement of the judgment. The delivery of the presumptive legitims herein prescribed shall in no way prejudice the ultimate successional rights of the children accruing upon the death of either or both of the parties, but the value of the properties already received under the decree of annulment or absolute nullity shall be considered as advances on their legitim. When we talk about legitim, ladies and gentlemen, this is the part of the testator's property, in this case, the parent's property, which the parents cannot dispose of because the law has reserved it for certain heirs who are therefore called the compulsory heirs. The children in this particular article are the so-called compulsory heirs. And under this article, once there is a judgment of annulment or the absolute nullity of marriage, kailangan there has to be liquidation, partition, and then afterwards, distribution of the properties as well as the presumptive legitim of the children. So, i-deliver na siya daan. Hindi pwede na hanging yung children. If there are properties, if the parents have properties, kailangan there is already a delivery of these presumptive legitims. But of course, in Article 51, it would tell us that this is without prejudice to the ultimate successional rights of the children accruing upon the death of either or both of the parents. Because it could be that the parents upon their death have already accumulated huge chunk of properties and yung estate nila varies from the time of the annulment or the declaration of the nullity of marriage. So, kailangan kwentahin pa rin yon. This is what the third paragraph of Article 51 would tell us. I hope that's clear. Article 52, the judgment of annulment or of absolute nullity of the marriage, the partition and distribution of the properties of the spouses, and the delivery of the children's presumptive legitim shall be recorded in the appropriate civil registry and registries of property. Otherwise, the same shall not affect third parties. So, kailangan i-record yan in the appropriate civil registry as well as in the registries of property. Alright? Article 53. Either of the former spouses may marry again after complying with the requirements of the immediately preceding article. Otherwise, a subsequent marriage shall be null and void. We have discussed this in the past, and remember that after complying with the requirements of Article 52, either of the former spouse may marry again, and to do otherwise renders the subsequent marriage null and void. Meaning, kailangan munang i-follow ng mga former spouses yung requirement under Article 52. Okay? Article 54. Article 54 provides that children conceived or born before the judgment of annulment or absolute nullity of marriage under Article 36 has become final and executory shall be considered legitimate. Children conceived or born of the subsequent marriage under Article 53 shall likewise be considered legitimate. I hope klaro na itong Article 54. Let's now go to legal separation. Basically, wala namang masyadong tanong dito sa legal separation, but I just would like to make a distinction between a legal separation and that of divorce. Yung divorce, there are two kinds. It could be absolute or relative divorce. When you say absolute divorce, the marriage in this case is really dissolved. Wala nang marriage. But with respect to relative divorce, the marriage here is not dissolved. What happens here is that the parties are merely separated from bed and board. So, ito yung tinatawag natin in our jurisdiction as legal separation. It's like a relative divorce. So, what are the requisites of legal separation? First, repeated physical violence or grossly abusive conduct, physical violence or moral pressure, itong attempt of the respondent to corrupt and induce the petitioner, common child, etc., etc. Final judgment sentencing the respondent to imprisonment of more than 6 years, even if pardoned, the drug addiction or habitual alcoholism, and so on. Also, the abandonment of the petitioner by the respondent without prejudice or without justifiable cause for more than 1 year. For purposes of this article, the term child should include a child by nature or by adoption. Itong mga grounds sa legal separation could be grounds also for psychological incapacity, but of course that would really depend on how you will establish the requisites doon sa psychological incapacity, like what we discussed yesterday, because there are physical manifestations that you could see here in legal separation na pwede mong gamitin when you file for a case of declaration of nullity of marriage on the basis of psychological incapacity. Article 56. The petition for legal separation shall be denied on any of the following grounds: when the aggrieved party has condoned the offense or act complained of. Condonation must be for one act only. One example of condonation is if you have sexual intercourse after the ground has arisen. Nasakpan na nimo or nahuli mo na nag-cheat sa'yo, but you still enter into a sexual congress with that person. Is that condonation? That is condonation. The presumption here is you're already in good terms, except when the sexual intercourse, according to the Supreme Court, was only allowed in the vain hope that the errant party would mend his ways. Akala mo because of the sexual intercourse, okay na or hindi na siya mag-cheat sa'yo. But still, bumalik pa rin siya doon sa kanyang old habits of cheating on you. So that is not considered as condonation. Another instances wherein the petition for legal separation shall be denied would be where the aggrieved party has consented to the commission of the offense or act complained of, where there is connivance between the parties in the commission of the offense or act constituting the ground for legal separation, where both parties have given ground for legal separation, and where there is collusion between the parties to obtain the decree of legal separation, or where the action is barred by prescription. There is actually a prescription within which to file for the petition of legal separation, and that is it should be filed within 5 years from the time of the occurrence of the cause. And remember that an action for legal separation shall in no case be tried before 6 months shall have elapsed since the filing of the petition. There is this so-called cooling off period. From the moment na you filed the petition for legal separation, the court will hold the trial in abeyance for at least 6 months. The court will consider it as a cooling off period kay baka reconcile pa yung parties. I'm having a hard time thinking of the Tagalog for reconcile. Baka mag-reconcile pa yung parties. So this is the reason why the law would place 6-month period, no, na i-hold muna yung action for the trial for the legal separation to give the party the chance to reconcile. But you have to remember that this article 58, no, this will be inapplicable if yung violence na specified as a ground for legal separation are those violence that is also specified in RA 9262. Pag yung inalleged ng wife or those types of violence mentioned in RA 9262, itong Article 58 of the Family Code shall no longer apply. And in this case, the court shall proceed on the main case and other incidents of the case as soon as possible. And the hearing on any application for a protection order filed by the petitioner must be conducted within a specified mandatory period of this article. Okay, so if yung basis or yung ground ng kanyang legal separation is, let's say, physical violence, and it is contemplated in article or in RA 9262, if these acts are among the acts contemplated in RA 9262, yung cooling off period ng 6 months will not apply. The case should proceed immediately, no? And if there be a prayer for the issuance of any protection order, mo proceed doon yung court without waiting for the lapse of the 6-month period specified in this article. Before we leave the topic on legal separation, I'll just have to discuss the effects when the decree of legal separation is issued. Una na effect under Article 63 is that the spouses shall be entitled to live separately from each other. But the marriage bond shall not be severed. Nandun pa rin yung marriage. Kaso lang, hindi na sila pareho ng bed and board. They are already living separately. Second, the absolute community or the conjugal partnership shall be dissolved and liquidated, but the offending spouse shall have no right to any share of the net profits earned by the absolute community or the conjugal partnership, which shall be forfeited in accordance with the provisions of Article 43, Paragraph 2, which we already discussed. And etong particular provision na ito, if you are the offending spouse, are you entitled to the fruits? If yung conjugal property ninyo is 2 million and then during the legal separation, naging 4 million. Yung fruits nito, you will actually or get the difference para makonsider mo as fruits. So the fruits of the 4 million from the 2 million conjugal property, yung naging fruits niyan is 2 million because it has become 4 million. With respect to the fruits, yung offending spouse, hindi na siya entitled. Okay? The guilty spouse is no longer entitled to the fruits of the 2 million. This is what is meant by this particular paragraph. Number 3 effect is that the custody of the minor children shall be awarded to the innocent spouse, subject to the provisions of Article 213 of this code. If the child is below 7 years old, in favor of whom ba should the custody be awarded? Of course, to the mother yan as a general rule. And why is it the general rule? Because according to the Supreme Court, there's no man who can respond to the sorrows of a woman seeing her child of tender age being torn away from her. But it is not the absolute rule, because if there are compelling reasons to separate the child from the mother, ang award ng custody should be to the father who is fit. If unfit yung father, may be to other persons, because in matters of custody of the child, the important consideration is always the best interest of the child. In Cervantes versus Fajardo, ang nangyari dito, yung mother may kabit. Okay? So, it reached the Supreme Court, and sabi ng Supreme Court in this case, that in all cases involving the custody, the care, the education, and the property of children, the latter's welfare is paramount. The provision that no mother shall be separated from the child under 5 years of age will not apply where the court finds compelling reasons to rule otherwise. In all controversies regarding the custody of minors, the foremost consideration is the moral, the physical, and the social welfare of the child concerned, taking into account the resources and the moral as well as the social standing of the contending parents. Never has this court deviated from this criterion. It is undisputed that the respondent Conrado Fajardo is legally married to a woman other than the respondent Gina Carrion, and his relationship with the latter is a common law husband and wife relationship. His open cohabitation with co-respondent Gina Carrion will not accord the minor that desirable atmosphere where she can grow and develop into an upright and moral-minded person. So, if unfit yung parent, the custody of the child will never be awarded to him or to her. That's Cervantes versus Fajardo. So number 4 effect is that the offending spouse shall be disqualified from inheriting from the innocent spouse by intestate succession. Moreover, the provisions in favor of the offending spouse made in the will of the innocent spouse shall be revoked by operation of law. So hindi na makaka-inherit ang offending spouse from the innocent spouse during the legal separation. And if there be any dispositions with respect to the will made by the innocent spouse, it shall be considered as having been revoked by operation of law. Articles 64 to 67 are matters of reading, so I suggest you guys should read all those provisions. We now go to Title 3, Rights and Obligations between Husband and Wife. The husband and the wife are obliged to live together, observe mutual love, respect, and fidelity, and render mutual help and support. It's very basic. The husband and the wife shall fix the family domicile, and in case of disagreement, the court shall decide. Unlike in the past na yung husband ang nagdi-decide, under the family code, fair na. They shall fix, both the husband and the wife shall fix the family domicile. However, if there be any disagreement, yung court yung magde-decide. And the court may exempt one spouse from living with the other if the latter should live abroad, or if there are other valid and compelling reasons for the exemption. However, such exemption shall not apply if the same is not compatible with the solidarity of the family. Article 70, the spouses are responsible for the support of the family. The expenses of the support and other conjugal obligations shall be paid from the community property. So these are basically matters of reading. Ang management sa household also the duty of both of the spouses. And if one of the spouses neglects his or her duties to the conjugal union or i-dishonor niya, yung aggrieved party may apply to court for a relief. Also, if you are already married, noon kasi iba yung concept nila when a woman is already married, you can no longer exercise your profession, you can no longer pursue your dreams, but under the family code, either of you may exercise any legitimate profession, occupation, business, or activity without the consent of the other. Except, of course, when it is based on valid, serious, and moral grounds. Okay? So, to recap, we have already discussed bigamous marriages. We have also discussed the grounds for the declaration of nullity of marriage. We have discussed the grounds for annulment of marriage as well as the legal separation. We have also discussed its effects, no? If there is already a decree of legal separation, if there's already a final judgment for the annulment or for the declaration of nullity of marriage. And we have also discussed the marital obligations of the spouses, katong to live together as husband and wife, so on and so forth. And of course, the free practice of legitimate profession of either of the spouse, even without the consent of the other, except on valid, serious, and moral grounds. Next week, we will be discussing the property relations between the husband and the wife and the other remaining provisions of the family code. And we will endeavor to finish the discussion next week so that the following week thereafter, we shall be having our oral recitation as well as our major examinations. Thank you very much, everyone. I hope you have a beautiful evening. Amping.